discrimination and how to make sure you don't get into all these sort of difficulties and end up with discrimination claims against you. So as we all know, the global state of the economy is not in good shape at the moment, and that obviously has a significant effect on the UK labour market. So there's a huge number of people vying for every vacancy that there is at the moment. And that means that if you get it wrong in the recruitment process, there are all these potential vexatious litigants out there who are likely to bring claims against you. And if you get it wrong, then you're likely to face claims not only from British people who lose out to jobs from migrant workers, but also migrant workers if they feel that they're being discriminated against on grounds of nationality or religion or belief. So as entrepreneurs and startup technology companies, you need to make sure that your business is well protected from the outset. So the Equality Act sets out the various protected characteristics, which are the grounds upon which you can't discriminate against job applicants. And you'll probably be familiar with them. There's age, disability, gender reassignment, marriage, pregnancy, maternity, race, religion or belief, sex and sexual orientation. So quite a long list. So you mustn't discriminate against people in terms of the arrangements you make for deciding whom to offer a job to, the terms on which you offer them employment, or by not offering them employment. And you also can't victimise or harass an applicant for employment. Now you need to bear in mind that you can be vicariously liable for the actions of your employees involved in the recruitment process. Now you will have a defence to any discrimination claim if you can show that you took all reasonable steps to prevent the discriminatory act from having happened. And that's why it's really important to have good and thorough recruitment processes in place. You need to be able to evidence the decisions that you make in terms of the recruitment decisions and the interview process, and the fact that your policies are consistently applied over a period of time. It's also really important to make sure that the people conducting the recruitment process do have regular training to make sure that they comply with a consistent process. Now, not only are you vicariously liable for the actions of your employees, but if you do use recruitment consultants, headhunters, agencies, you're vicariously liable for their actions as well, because they're acting as an agent on your behalf with your instructions. So data protection, you probably all know far more about it than I do, because you're all techie and I'm not. But you will be aware that as job applicants, they are data subjects, and they're providing personal data to you as the data controller. So you have to be very careful about how you deal with the applicant's personal data. So some of the issues you need to think about relating to data protection are on the slide. So in relation to the successful applicant, you should only transfer to their personnel file or their HR file information which is relevant to the ongoing employment relationship. Now, lots of companies keep speculative applications, so good CVs on file in case a good vacancy comes up for which this applicant may be a good candidate. But you should actually be informing applicants that that's your practice and giving them the opportunity to not have their details kept on file. Now, it's really, really important for you to cover your backs and make sure that you do have a really careful paper trail of the whole recruitment process, right from the beginning to the end of the process when you give an employment contract to the successful candidate. And that will minimise the risks of successful discrimination claims being brought against you. So all documentation relating to the recruitment process is potentially disclosable in litigation proceedings. So you need to be really careful what you write in interviews. So handwritten notes on CVs, it's all disclosable. So keep that in mind. All the decisions that you make are equally important, and you need to be able to justify your reasoning behind every decision that you make. So you have to base your decision on objective reasons which are obviously non-discriminatory and are based on someone's ability to do the job on merit rather than sort of stereotypical assumptions about certain categories of people. So, for example, you shouldn't assume that because someone tells you at interview that they're a mother, that they won't be able to work full-time or they won't be able to work 9 to 5. So I set out on the slides all the records that you should keep in terms of the paper trail. If anyone wants copies of the slides, I'm very happy for you to email me, and I'm happy to let you have copies afterwards. So looking now at training, I'm imagining that you're probably fairly small, so you probably don't have in-house training capacity. So that's why it's important to come to seminars like this, so that you can show that you have been trained about equal opportunities and recruitment processes. So and that would be important, obviously, if any such claims were brought against you. But the kind of training that would be useful to have, and we can come in-house and do training sessions for you, is to recognise if and when people are making stereotypical assumptions about candidates, to be able to apply scoring methods objectively, which is more difficult than it sounds, to be able to prepare questions based on job and person specifications, and to basically make sure that you don't ask really inappropriate personal questions which are unrelated to the actual job. And you'll be surprised how many times I've been asked whether I was planning to get married and have children not that long ago. Not on my current firm, I'm glad to say. So looking now at the job description, the person spec and the advertisement, you need to be really careful with the job title to make sure it doesn't show a predetermined bias for someone with a particular characteristic. Be really careful with the language that you use in advertisements to make sure you don't face claims from vexatious litigants, as we've just heard about, and make sure that you use gender neutral terms. It's all fairly obvious stuff, but people do get into muddles with this. So in summary, avoid references to protected characteristics in the job adverts or the job specs. Don't ask for continuous experience, because again that could indirectly discriminate against people on the grounds of age, or particularly women or men who've had time out for childcare responsibilities, maternity leave, paternity leave, etc. Only include the criteria that you genuinely need to perform the actual job. So for example, if you want someone to come in and do data inputting or programming for you, don't ask for people that are really young and energetic, because basically it's a sedentary job and it's going to potentially discriminate against people with a disability. Now, how many of you use social networking sites to vet or get more information about potential applicants for a job? Only one. Okay, that's great news, because actually it was the title was completely wrong. It's basically why you shouldn't be using social networking sites to vet applicants. But you're not alone. Lots of people do that, but it is very risky. There was a survey a couple of years back which found that 50% of employers do use social networking sites such as Twitter, LinkedIn, etc., Facebook to vet potential candidates. And apparently 35% of them found content that did dissuade them from hiring the candidates, but you are at big risk of claims for discrimination if you do that and you're found out, and also potentially breaches of the Data Protection Act. So we all know there's lots of stuff, there's lots of photos posted on social networking sites, but they can be misleading, and there can also be cases of mistaken identity. And even if you do find the right candidates online, if you find stuff out, for example, about their religion or their race or their sexual orientation, and that puts you off then shortlisting them for interview or interviewing them, then you could face sort of expensive discrimination claims. So basically, you shouldn't really do it. Yes?
We are a social media company, and as such, we need them to have a social media profile. So we ask in the interview process for them to give up their LinkedIn, their Twitter, but not their Facebook. So it is vetting.
Twitter's more risky. I mean, LinkedIn is an acknowledged business networking site, so basically people shouldn't be posting photos other than sort of work-related photos on their
because you can't
websites.
See a lot of Facebook ones, so we don't even bother with Facebook. But we do look at Twitter because we need to see the kind of things that are relevant for what we're looking for.
But do you ask for their personal Twitter accounts or just business-related Twitter accounts?
We ask for their Twitter accounts. So I would assume personal. I would assume that it would be whatever Twitter accounts that they're working on.
I would be concerned about that, because they might be saying, "Oh, got smashed last night at the local gay club" or something, and then if you don't, if you don't, I don't know what people put on Twitter. I don't tweet, but
my Twitter account.
Surely they would, before giving it to us, they would have the choice to go through and take any of that.
But can you see? I'm not. Can you do that?
Can stuff? Yeah, of course.
I kind of thought that once it's out there, it's kind of out there forever.
You can you can delete it off your own page. If somebody's retweeted it, you can't.
Yeah, that's the difficulty.
Yeah.
I mean, I had one where I was acting for a senior executive who signed a compromise agreement. So, do you all know what compromise agreements are?
Yeah.
No? Okay, so when you leave employment, if the employer pays you money to waive your rights to bring any claims against them, you sign an agreement. And one of the things in there is what I call the non-slagging off clause. But it's basically, you say that you won't say anything derogatory about the company or any of its employees, etc. And they won't, normally they agree not to do the same about you. Anyway, so this guy got hundreds of thousands of pounds. Payable in instalments. They then go onto his Twitter account and he's referred to, not on a name basis, but he's referred to ex-employees as the evil ginger leprechaun, and I won't tell you the other names that he used to describe them, but it was fairly obvious that there was only one ginger employee and they worked out who it was, and he said, no, I wasn't referring to an employee, it's just how I referred to, I don't know. But anyway, he ended up only getting half of the money because he was a bit silly. So I think that the moral of the story is be very careful what you put on Twitter, because employers do use it, and as employers it can be used against you if people find out that you've made a decision based on sort of personal information that they may have put on Twitter. So you need to be careful. There is also what's known as the Information Commissioner's Employment Practices Code, and that sets out guidelines for recruitment in relation to vetting people. Vetting is intrusive because you're actively, as an employer, making your own inquiries from third parties, which goes beyond what the applicants told you in their application form. And you do need to strike a balance between your needs and the applicant's right to privacy and respect for a family life, etc.
How old are these laws? Because I've heard stories of graduates my age getting told that they won't get a job because employers seeing them on Facebook and doesn't like how they behave.
That is potentially discrimination. It depends on what sort of behaviour.
I think just photos they've seen.
I think your friends need to be careful what they put on Facebook,
Yeah,
because they need to be aware that even though there are these guidelines, 50% of employers do still look on Facebook and look on. Yeah, I mean, they shouldn't be doing it, and your friends could draw it to the Information Commissioner's attention. But the bottom line is employers do still do it, so I think people need to be careful what they put on social media sites. But these are the main guidelines, the Information Commissioner's main guidelines about vetting potential applicants on social media sites. So you should only vet employees working in high-risk areas. That wouldn't be applicable to you, so it would be sort of government workers with access to highly classified information, or people with access to children, childcare teachers, etc. So it wouldn't apply to you. You should only vet if there are particular and specific risks involved to you as the employer or your clients or customers, and that there's no less intrusive or reasonably practicable alternative, and in most cases there will be. Only the candidate that you actually select for the job should be vetted, so you shouldn't be vetting all potential applicants, and again that's where a lot of employers do get into trouble. You should tell the candidate that you're going to vet them and that how you're going to conduct the vetting process, and then you shouldn't keep vetting information for more than 6 months. You should destroy it within that period.
If you have in the contract that the employee cannot make derogatory remarks, statements about the company, and then you don't know their, say, Facebook profile, but you're told that they posted something derogatory on their Facebook profile, how would you address that?
Well, that would be fine. This is more in relation to when an employee leaves your employment, if you get them to sign what's called a compromise agreement.
Not necessarily if during the term of their employment they're having their contract that while they're employed they cannot make derogatory statements of the company.
Yeah.
Well, either way,
if
they for some reason cannot are on their obligation to do that, but they do that on Facebook or Twitter.
Well, then that's fine for you to get that information. There's not an issue because you're not using it as a grounds to discriminate against someone. It's you've been told that they've acted in breach of contract and someone's given you the evidence to prove that they have breached the contract.
So
that's...
You would not necessarily have to explain how you got to, be aware of this.
Well, you would. I mean, when you call them to when you call them to an investigatory meeting to investigate the misconduct beforehand, you would have to give them copies of relevant evidence, and you'd have to set out in detail what the potential allegations against them are, so that when they come to the meeting they know what the case against them is that they have to answer, and they've seen all the evidence that you've seen. There shouldn't be any surprises, otherwise you would be following a fair process, and you'd be looking at if they have the requisite length of serious potential unfair dismissal claim. So you need to be careful about that. But I mean, you can draw that evidence to their attention, provided that you give it to them in advance of the meeting so that they can prepare. Application forms. When I was applying for jobs, you just used to write a cover letter and a CV. I'm probably giving away how old I am now, and I shouldn't do that. But nowadays I'm told that you just have application forms, and that's a far better way to conduct things, because it means that everybody is judged equally on their merit. So application forms are the way to go, rather than cover letters and CVs. Also think about potentially disabled applicants. So you're all techie, if you're able to provide sort of larger print application forms or braille or things like that, then you should think about potentially disabled applicants and what you can do to help them with the process. Now, this was a hot potato a few months ago, and Andrew's going to talk about this in more detail. Andrew's my immigration partner. And it is a hot topic in the news at the moment. Should employers recruit unemployed Britons over foreign workers? And I'm sure that you've all got your own views on this topic. But a couple of months ago, Ian Duncan-Smith, the Work and Pensions Secretary, urged employers in the UK to give our young people a chance and not fall back on labour from abroad. Now, as employers, if you were to follow his advice, you could be opening yourself up to potential claims for race discrimination by unsuccessful foreign applicants, so you need to be very careful. Compensation for race discrimination is unlimited, so it's based on an applicant's actual losses going forward. There's also a separate category of award known as injury to feelings, and it can be as much as £30,000. So getting it wrong in terms of discrimination claims is expensive, so you need to be very careful to make sure that you're not potentially discriminating against someone, but at the same time as an employer you also have legal obligations to make sure that you're not employing people illegally. So, here are some practical do's and don'ts to minimise your potential exposure to race discrimination claims when you are recruiting potential applicants from abroad. So don't carry out identity checks on workers who you believe are not British because of their race or ethnicity. You shouldn't assume that just because someone's from an ethnic minority and that they're an immigrant, or that someone born abroad isn't entitled to work in the UK. And this is another one. Online application forms. There is a law firm called Osborne Clarke, and they got into difficulties with this because there was a foreign national who applied using their online application form, and it got to the point where it said, do you have the relevant immigration approvals to work here? And I think he didn't, and then his application wasn't able to proceed any further on the IT system. Now that was a very difficult case, and employers are still trying to deal with the practical ramifications of it, but the upshot is that information about eligibility to work in the UK should only be verified at the very last stages of the recruitment process. And that's to make sure that the appointment is based on merit alone. So you do need to factor the length of time it will take to obtain the relevant immigration approvals into your recruitment process. You shouldn't make assumptions based on racial or national stereotypes, and you shouldn't treat applicants in a certain way because of these stereotypes. So don't automatically reject all refugees, and don't assume that someone with overseas qualifications and experience is less valuable than those obtained in the UK. Again, you shouldn't request a high standard of English if it's not a if you don't have a genuine need for that. Don't reject applicants just because they have unfamiliar accents. When you do make pre-recruitment checks, make sure that you do it consistently for all applicants at the same time in the process. And make sure that job selections are on the basis of merit for the post in question. So you should only ask questions about an applicant or an employee's immigration status where necessary, where you're trying to determine whether their status imposes limitations on the type of work they can do or the period for which they can work, etc. It is good practice to monitor the ethnicity of your job applicants during the whole of the recruitment and selection process. and that's to make sure that you're reaching a potentially wide range of applicants. Now, it's not on the slide, but another issue that has arisen because of the points-based immigration system is where migrants are paid higher salaries than domestic workers doing the same job. And that's to increase their chances of obtaining a work permit, and you can talk a bit more about this. But you need to be aware that in such circumstances you could face race discrimination claims from domestic workers doing the same work but being paid less than migrant workers. Also, under the Equality Act, pay secrecy clauses. So some employers used to have provisions in their contracts which prevented people from discussing their pay or bonus with other employees. It used to be because of the discrepancy between what men and women were paid. But again, an employer can't rely on a pay secrecy clause to prevent domestic and migrant workers working out whether there is a discrepancy in pay based on their nationality or ethnic origin. So you need to review the level of pay for various grades of workers to make sure that workers of the same grade are being paid at a consistent level. You look really confused.
Right, so if, not talking about migrants in particular, but if you manage to get a good person at a certain price, and then you have to start a different project very quickly, so you get a different person who is less qualified, but you need them right now, so you pay them twice more. And for these two people do the same job, they're paid very different amounts of money. Is this potentially a problem?
If they were to find out on one of them, if the person paid less, for example, was a woman and said, you're paying me less because I'm a woman, then there could be problems there.
Right, but you're actually paying her less because you employed her at a different time. The reason is different, it's not really discriminatory. How
if it's not discriminatory and you have a genuine business reason for paying someone at a certain level, then that's fine, but you should be aware that if people become aware of it, they may try and look for discriminatory reasons to challenge it.
How do you document that? How do you make sure that you don't? So in many companies, it's when you go to work there, it's about how you bargain before the start, right? So there may be very significant differences between people at the same skill level. So obviously, if they find out that some people will be unhappy and some of them may start, legal action. How do you make sure this is the kind of policy you have in your company, that it's okay if people at the same level have different salaries? How do you tackle that legally?
I mean, you need to be able to explain the reason. So it may be that someone has a better qualification, or has specific language that you need, or there may be certain skills they have that other people don't have that would justify.
Or if there's just a bit of bargain before that, or you get funding, you need to spend this money now, you get new people at high.
Well, as long as it's not on discriminatory ground, then I can't see the basis upon which they could bring a claim.
So the first person was from an ethnic minority, the second person who got after funding is not from an ethnic minority. And you could say,
well, then you would say, well, the reason isn't because of your nationality, it's because of changing business circumstances, and I had this funding and I needed to spend it within a specific period of time.
You need to produce some kind of evidence for that, like
well, if they were challenging it, you should have documentary evidence to back up any decision that you make, and ideally it would be contemporaneous if possible. So what you can and can't ask at interview. So you should assess everyone objectively during the interview process and solely on their ability to do the job to a satisfactory level. So you should ask all candidates the same questions, but then obviously depending how they answer the question, you can ask supplementary questions that will differ. But what you have to be really careful not to do is to ask personal questions which are irrelevant to the job in question and could imply discrimination. If candidates do volunteer personal information, and sometimes when they're nervous they do sort of talk a bit more than they should perhaps and tell you things that aren't completely appropriate, you need to be really careful to ensure that you're not influenced by what they tell you. So there was a case called Chorus Hotels in Woodward where the employer had to pay the candidate £4,000 for injury to feelings because she mentioned that she had children, and then he just assumed that she wouldn't be able to hold down the job on that basis, and that was a wrong assumption. Something that clients often ask me is whether female employees are under any obligation at an interview process to tell the potential employer that they're pregnant. And the answer is no, they don't. And the strict legal position is if they do mention that they're pregnant, you shouldn't take account of it when making the decision whether to recruit them. The practical reality is that that's when you would pick up the phone, hopefully to me, and I will advise you how to avoid sex discrimination claims in those circumstances. As we heard before, there are certain things that an offer letter or contract has to set out in writing, and that's all contained in Section 1 of the Employment Rights Act. I won't bore you with all the detail now. There are a number of conditions precedent which you should consider including in your offer letter. So the offer is conditional on certain things. They're listed on the slide, but important things are confirmation that the employee is actually free to work in the UK or has the appropriate work permits or immigration approval. At the final stage, you can ask them to undergo medical if necessary for carrying out the job. Really, really important to check that they do actually have the qualifications that they've told you they've had. There's been lots of sort of horrific press stories where you've had very senior executives in banks where they've been doing sort of multi-million-dollar transactions, and actually turns out that they don't have the qualifications that they said they had at all, and it's a complete PR nightmare for the company. Important to check that they won't be in breach of any restrictive covenants in their existing employment contract by joining you, so that, particularly if you're a competitor, do they have a non-compete in their contract that would prevent them from joining you. Yeah, the rest of it probably isn't that relevant for you. I'll touch very briefly on references. Offers should be made conditional on receipt of satisfactory references. It's good practice to send the referee copies of the job description or person spec to make sure that you're not just getting their subjective opinion about the personality of the person you're employing, but actually are they capable of doing the job in question. References won't always give a kind of full and complete accurate history of the employee's sort of working life, particularly if they have left under a compromise agreement, because in those circumstances normally you would agree the wording of a reference unless they're an approved person for FSA purposes, which really won't be relevant for your purposes. So just be aware of that. And also lots of employers have practice of just having standard references, which is just job title, dates of employment, salary, and that's it. So just be aware that the references may not actually say very much. So I'm now going to hand you over to my business immigration partner, Andrew Tingley, who will bring you up to date with all the changes. But any questions, I'm happy